Welcome back. In honor of Independence Day, today's video is going to be a little bit different. We're talking about the history of estate planning in the United States. However, after breaking away, our law began to take its own distinct shape, especially when compared to our English counterparts. So hit the like button and let's jump back in time. Picture it. We're back in the colonial era. The settlers from England have just come over and they've brought with them the system of primogeniture. What's that? Well, it's a fancy term that means the oldest son inherited all of his father's estate. But after our forefathers fought for independence, we said goodbye to King George III and to primogeniture as well. The democratic ideals of our newly founded country led to paritable inheritance, a system where an estate is divided among all the heirs equally. Fast forward to the 19th century, an era of industrialization and wealth accumulation in the US. Estate planning began to look more like what we recognize today, with wills and trusts becoming more common. From the War for Independence through the 19th century, taxes on estates and inheritance did exist, albeit temporarily, to pay for the budding nation's expenses, primarily fighting various wars, including our Civil War. However, in 1916, to fund World War I, the federal government introduced an estate tax on the transfer of wealth at death that has been with us ever since. And the evolution didn't stop there. The mid to late 20th century brought in more changes to tax laws affecting estate planning, including the introduction of the unlimited marital deduction in the 1980s, which lets spouses leave any amount of property to each other without incurring an estate tax. Talk about a love letter from your spouse. During this time as well, it became increasingly more common for folks to have A, B, or even ABC type trusts, where they were used to lower the overall value of one's estate by creating multiple estates, thus doing something that is American as apple pie itself, doing our best to stop the government from taking all our money through taxes. Now we're in the 21st century, and estate planning has become more complex with changes in tax laws, the rise of digital assets, and the evolving nature of family structures. Today, estate planning isn't just about the transfer of financial wealth. It's about planning for your future, your family's future, and the legacy you want to leave behind. Now you may be wondering how estate planning has developed in other parts of the world. Well, let's hop across the pond and take a quick look at our cousins in the UK. The Brits also began with the system of primogeniture, which is the system we initially inherited, of course, but they held on to it a bit longer, especially among the aristocracy. However, it's no longer the norm. Next, let's talk about everyone's favorite topic, taxes. Both countries have taxes on the transfer of wealth at death, but with some different accents to it. Here in the US, we have the federal estate tax that's based on the net value of the entire estate. However, in the UK, there's an inheritance tax paid by the person who inherits the estate, not the estate itself. Keep in mind, there are also a few states here that also impose an inheritance tax, but fragmented state law is a feature of our American experiment, not a bug. How about trusts? Trusts are common in estate planning in both countries, but trust law in the UK has gone further than it has here in the US and has reduced some of the tax benefits of certain types of trusts. Contrast this with the US, where we use trusts to avoid or at least reduce estate taxes, as well as avoid probate entirely. And of course, we can't forget about marital property rights. The UK doesn't have a community property system, while again with our fragmented system here, we have 13 states that are community property states, California being one of them. This community property distinction can play a role in affecting how property is divided at death, but most commonly comes into play at divorce. This brings us to professionals. Here in the US, estate planning has become a specialized field of law, but in the UK, while there are lawyers who focus on estate planning, it's not as distinct from other areas of law. So even though we share a common historical root in English common law with the UK, the different paths we've taken have led to a lot of unique practices in the field of estate planning. For a quick bonus fact, Louisiana is a very unique state because it doesn't have its basis in English common law, but French civil codes, which derive from Napoleonic Codes. This is due to Louisiana being French territory before being sold to the US, along with a massive swath of land known as the Louisiana Purchase in 1803. A section was segmented off from the overall purchase and became known as the Territory of Orleans before later becoming the state of Louisiana. Needless to say, this has led to some differences in the development of law in Louisiana when compared to the rest of the country, particularly around real property law. There's a lot more history there, but we'll leave that there for now. But hey, enough about history, let's talk about your future. If you've been thinking about setting up your own estate plan, then speak with an experienced estate planning attorney, like me. And if you found this journey through history surprising, or at the very least interesting, then leave a comment below and let me know. Otherwise, hit the subscribe button and don't forget to ring the bell so you won't miss any of our future videos. Happy 4th of July, stay safe, and I'll see you next time.